Hi, everybody. It's Jeff Round, the Executive Director here at the LSNT. And today I am pleased to introduce Frederica Wilson, who's going to deliver Trust Accounting 101 as your CPD today. Frederica Wilson is the former Executive Director of Policy and Public Affairs and Deputy CEO of the Federation of Law Societies of Canada, the national coordinating body of Canada's law societies. In that role, Frederica oversaw the Federation's major policy initiatives, including its anti-money laundering projects. Frederica currently acts as an advisor to law societies on matters related to anti-money laundering and related issues, and she's been a member of the Law Society of Ontario since 1993. And before delivering this and the recent anti-money laundering CPD, Frederica assisted the LSNT by developing some forms for anti-money laundering and guides as well for trust accounting, which she will discuss with you today, and they are posted on our website, so please check them out. And I'll just take this opportunity because I haven't spoken with Frederica since the last one. I thank you very much for all of your work on these forms and guides and also the preparation of these CPDs on very important topics for our members. With that, I will turn it over to you.
All right, great. Thanks very much, Jeff. And thank you all for attending today. As the title of the session implies, this is an introductory session to trust accounting obligations. Just give me a moment. I'm going to share my screen. All right. So as I mentioned, this is a introductory session to trust accounting, and I think it's a good place to start is to talk about why you should care about this. Most of the session is going to talk about the rules, the obligations that you have under the Law Society's rules, and indeed under your professional rules of professional responsibility. But I want to start by taking it back a step and talking about why you should care about trust accounting. Perhaps this isn't entirely the best place to start, but it's worth knowing that failure to properly take care of the funds entrusted to you by your clients, either through ignoring the trust accounting rules or not doing them properly, not respecting them properly, is one of the leading causes of discipline and indeed disbarment of lawyers across Canada. You don't want to be part of that statistic. But let me say that there's an even better reason for caring about your trust accounting obligations, and that is your trust account, money in your trust account belongs to your clients. You have a fiduciary obligation to them. They are trusting you, as implied by the name, to look after their money. And it's important that you do so with diligence and with integrity. There's another thing I'm not going to spend much time talking about, but another reason to care about this is that anytime you're engaged in a financial transaction on behalf of a client, whether that is actually conducting the transaction or providing directions on a transaction, there is a risk that your services could be used to facilitate money laundering or the financing of terrorist activities. There are whole sets of rules. Your law society has whole sets of rules. I gave a previous presentation on those, and lots of information on your law society's website that talk to you about anti-money laundering. But suffice to say that diligence in the handling of money that comes to you and into your trust accounts on behalf of clients is one of the ways you can safeguard yourself from unwittingly becoming involved in money laundering activities. And that is something that you will certainly want to avoid doing. Okay, so what are we going to talk about in this session? We're going to talk a little bit more about what trust money is. We're going to talk about steps that you have to take in this law society before you can open a trust account, briefly about the types of trust accounts, handling deposits and withdrawals from trust accounts, what to do in the event of a trust shortage, trust account reconciliation, really quick look at all the various trust accounting records you must keep, and reporting obligations that you have under the Law Society's rules. At the end, I'm also going to introduce you to some of the resource documents that Jeff referred to in his introduction. Okay, so first of all, trust money is any money that you receive in connection with legal services that you are holding for the benefit of the client. This can include retainers. It can include money that a client has given to you because they are purchasing a piece of property, money that's transferred to you in trust that you're holding until there's a fulfillment of trust conditions and so forth. It's worth talking just briefly about money that is retainer. Um, Retainer money, of course, ultimately becomes yours, but it goes into your trust account until you have billed your client for the services that are related to that. Okay, because I started with talking about why trust accounting matters, I'm going to skip over this slide kind of quickly. But just to say that trust accounting, there are a lot of rules, right? A lot of rules, and there's a lot of fussing about records and numbers and so on. But when you keep in mind why you have to do that, why it is so utterly critical that you do it properly, I think it's a little easier to make your peace with the I don't know what I was going to call it a burden, but I don't really want to tell you it's a burden, but the demands of trust accounting. Fortunately, there's trust accounting software that can assist you with this. All right, so we're going to spend most of this session talking about the rules and the obligations under the rules. But I want to start by saying you have to ask yourself a question from the get-go if you are opening a law firm, for example. And that question is, do you even need a trust account? Not every law firm needs a trust account. It really depends on the kind of practice that you are undertaking and the way that you structure your practice. So the obvious question, as posed on the screen, is, if you receive money, do you receive money for your clients to be held in trust? If so, you must have a trust account. But if you don't, even if you are billing them, if you, for example, do not take a retainer, but simply bill them for services and they send you the money after you have billed them, same thing for disbursements, which is not uncommon in certain types of practice areas, then the chances are you don't need a trust account and your life will be a little bit easier. Okay. So the Law Society of the Northwest Territories is one of a number of law societies that require that you get approval before you open a trust account. Running a trust account is a privilege and not a right. And while it is essential for certain types of practice, you still have to meet the standards that the Law Society has set. So to qualify for approval, at least generally, is not overly onerous. You have to have a member of your firm who's a member of the Law Society. You have to have a responsible lawyer. Now, I'm not going to go into a lot of detail about that, but I hope that you know that you have to name a responsible lawyer. You have to designate a particular person to be that responsible lawyer, and that's the person the Law Society is going to rely on in their communications about things such as trust accounting. Your firm must carry on business in Canada, and you have to use approved accounting software. And that's a good thing, the accounting software. I've had a look at the accounting software, and if you are not already using it, if you don't have a trust account yet, or you're not the person running the trust account, have a look at it because it's really has transformed trust accounting from the days when I was in private practice. Okay, so you probably all know this. There's two types of trust accounts, pooled trust accounts and separate interest-bearing trust accounts. Pooled trust accounts are the accounts most commonly used. They are, as their name suggests, an account in which the funds of a variety of clients are pooled in the trust account, and interest on those trust accounts is remitted to the Law Foundation. Across Canada, that's how law foundations are funded. So law foundations do a lot of important work in a variety of areas, including access to justice, and that money comes from the interest on pooled trust accounts across the country. However, there are circumstances in which you may have a separate interest-bearing account for an individual client. This is common with major corporate transactions, for example, where even if the money is not in trust for a long time, the amounts are so significant that there may be significant interest earned. And the Law Society's rules have specific provisions for each of these types of trust accounts. They have to be designated as trust accounts. They, in the case of the separate interest-bearing trust accounts, the name of the client for whom you are opening the trust account must be included in the name of the account at the financial institution. You have to, as I mentioned, on a pooled trust account, the interest is remitted to the law foundation, and that requires you to instruct the financial institution you're using that they must do so. So the Law Society has precedents for on the website for communications with your financial institution to get that done. Okay, so there are other basic provisions. The first one is that the funds must be held at a financial institution that is located in the Northwest Territories. As I mentioned, you have to instruct the financial institution to remit the interest on a pooled trust account to the law foundation. And the pooled trust account is in the name of the law firm, and it must say on it that it is a trust account. I should mention here, although I'm not going to go into it, there are relatively new obligations that are related to the Canada Deposit Insurance Corporation and how we let them know in the case of financial institution failure on whose behalf the money in your trust account is held. There is information on your Law Society's website about those obligations. Okay, so the rule that I have highlighted on the screen right now is a rule that restricts the use of your trust account to circumstances which are directly related to legal services that you or your law firm are providing. Only those monies may be deposited to your trust account. In the past, lawyers were able to and sometimes did use their trust accounts for a variety of things, even when they were not providing legal services. This is a major money laundering risk. And about a little less than 10 years ago, working through the Federation of Law Societies, the Law Societies of Canada decided that a rule that was already in place in a few jurisdictions should be recommended to all law societies for implementation. And that is this rule that restricts the reasons for which you may deposit money into a trust account. So the fact that you have a client and the fact that your client might ask you to put money in your trust account is not sufficient. And there have been prosecutions and disbarments in law societies in Canada where lawyers have done that, even before this rule came into force, where they have done this in very suspicious circumstances with large amounts of money, where the trust account was simply used as, the term we use is mere banking. The money went in, the money went out. No legal services provider. The lawyer in question got some kind of a percentage payment for that. You can't do that anymore. And this applies whether the funds are going into a pooled trust account or whether they're going into a separate interest-bearing trust account. So the rules, there are a lot of rules. A lot of your rules are dedicated to trust accounting because it is an important I was gonna say complex. It's not that complex, really. You have to track the money, right? You have to keep careful track of the money. You can never withdraw money out of a trust account that isn't there, can't be overdrawn, and so on. These are basic rules, but there's a lot of record keeping and a lot of specific directions in the rules. So the first thing is that you must deposit money into your pooled trust account within a reasonable amount of time. So you can't hang on to it. Your client gives you a check. You don't hang on to that for weeks and weeks before you deposit. It needs to be deposited into the trust account. And it's not in your trust account and available to be used for any purpose until, for example, if it's a check, until that check has cleared. That's a really important thing to keep in mind. Lawyers can and do get into trouble in circumstances where they deposit a check, looks good, they think it's good, they have a quick turnaround on a financial transaction for a client, they've paid the money out before that check has cleared, and the check is not good. That is that's a form of fraud that is perpetrated on lawyers, unfortunately. Or it can simply be that the client isn't handling their money well on the other end. But in either event, you are on the hook. You are in trouble in that situation. So it's really important to understand that, there can be a delay between depositing a check and that money being credited to the account, and that applies here as well. You also have to deposit all trust monies into the pooled trust account, even those that are then going to be transferred to a separate interest-bearing trust account. In circumstances where you might get, for example, a check that covers both work you've done and billed for, so you are already entitled to that money, and other things that you are not entitled to or perhaps are never going to come to you, like payment for a piece of property. But if there's one check, it goes into the pooled trust account. If you have already billed for services you've rendered an account, you may then transfer the money for your bill to your general account. But you can't do it the other way around. It can't go into general and then over to trust. It has to go to trust first. Okay. There are even more rules about how you withdraw money from trust accounts than there are about how you get it in there in the first place. As I mentioned a moment ago, you cannot withdraw money from a trust account before the funds have been deposited and cleared. A lawyer of the firm has to sign for all withdrawals, and that there's some significance to that signature. That is, in effect, an attestation that your records are current, the withdrawal is legit, you're permitted to disperse the money. It's not subject to trust conditions. Your client has the funds in the trust account, and the trust account itself has overall sufficient funds. And there's a really important concept buried in that, and that is that even if your trust account, I'm going to make up numbers which may have no bearing with reality at all, but you have $1 million in your trust account and $25,000 belongs to client A. You've just deposited that check in the account and it hasn't cleared. You cannot draw from the rest of the money to make a disbursement for that client. You may not do anything on behalf of that client or their money until that money is actually in the trust account. That's an important thing to understand, that although it's pooled, although the funds are pooled, your record keeping is going to identify which client has how much money in the trust account, and you must always respect that. So it's just as if they had their own account and their $25,000 hasn't shown up yet. Until it does, you can't disperse anything out of that account. Okay. You have a couple of options for how you get money out of a trust account. You can do it by consecutively numbered checks, and providing you meet certain conditions, you can also do it through an electronic transfer. What you can't do is go to the bank and get cash out of a trust account. All right. You shouldn't have trust shortages. Ideally, you don't have trust shortages, but sometimes there's an accounting error and you might end up with a trust shortage, or there's a problem that you're sorting out with the bank. So what happens if you discover that you have a trust shortage? If you're not the responsible lawyer, you advise the responsible lawyer immediately, and the responsible lawyer must notify the Law Society, specifically the executive director. If you cannot correct or have not corrected the deficiency within 7 days, or always immediately if the amount of the deficiency exceeds $2,500. So there could be an issue with a bank that hasn't credited, or it's credited to the wrong account. So the money will be there and you're sorting that out with the bank. That's why you have 7 days before you have to notify the Law Society. That's the kind of circumstance in which there can be a shortage that is not attributable to any fault of the lawyer or any malfeasance. Okay, now we get to the part that everybody loves. I don't know about you. I'm old enough that, we didn't have electronic banking when I was young and starting out. And so, yeah, I had to reconcile my checkbook. I was terrible at it. I hated doing it, but it was only one account. Lawyers have to reconcile all trust accounts, if you have more than one, all trust accounts every month. So it's not that complicated a procedure, really. It involves comparing what the bank says is in the trust accounts and what your entries in your trust journals and client ledgers say. That is the tool that you use to make sure that you are on top of any problems that might arise in the trust account, that you know that the money that is supposed to be there is there, and if it's not, you figure out where it is, what's happened, and you correct it. It is also ultimately a guide, a guard against potential internal fraud. Not that that happens often, but unfortunately it does happen from time to time. There are corrupt lawyers. So when somebody else is looking at the trust accounts, they have an opportunity to see any problems early. So at the end of the day, what your records say should be in a trust account, and what the bank's records say should be in a trust account need to agree, or have any reasons must be identified. So it could be that a check has been deposited, but it hasn't cleared, or alternatively, that you have issued a check to the client, but the money has not yet been withdrawn from the account because that check has not yet been negotiated. So there are ways of accounting for that. And at the end of the day, once you have accounted for those entirely understandable and legitimate reasons why there may be a difference, you have shown why and managed to say that the amounts do or will shortly agree. You have to do this once a month. So it's within 30 days of the date of the reconciliation. So if you were, for example, wanting to reconcile up to the end of June 2026, you have 30 days from the end of June, so into the end of July, to get that reconciliation done for that month. It's really important to stay on top of that. It's a whole lot easier to reconcile any discrepancies in that short time period than to let them pile up. Okay, so I'm going to actually try and click on this and see if I can get it to come up, but I'm not. You already saw that I'm a bit technologically challenged at times. So Jeff mentioned that we've created some resources. The first two that I'm mentioning here are a trust account reconciliation overview and then a template, a reconciliation template to assist you with reconciliation. I should say that some of the accounting software that exists has the capacity to do the reconciliation within the let's see what happens. Is it going to come up? There we go. Can you see that? I hope somebody can. So you are, of course, all duly muted. So if you can't see a new document, let me know. It says Trust Account Reconciliation Overview. And this really is just kind of, I'd call it a cheat sheet. It's a page and a half, page and 3/4 long, not overly complex, but it takes you through what you have to do to reconcile. What are the steps involved in reconciling a trust account? So this is just a basic uh, uh, guidance document, I would call it. Then the second document, let's see if I get to it. This is just a form. I'm showing you the PDF version. I imagine, as Jeff has done in some other case of some of the anti-money laundering documents, that this may be also posted in a Word form, which is probably ultimately more use to you. But it really just shows you what you have to do at the beginning. You're starting with what the bank says you have in it, plus any outstanding deposits, so things that have been entered in your trust journal but are not yet showing up, minus any outstanding checks. I mentioned you've issued checks, but they haven't yet gone through the account. Any other adjustments. You get the adjusted bank balance. You take a look at whether or not what the total is in your trust ledger. And you have to look at your client listings, so the amount per client as well. And that's the process. It's not rocket science. It requires attention to detail. It's, I think, a fair way of putting it. Okay, so I'm just going to see if I can. I mentioned there are a lot of different records that you are required to keep. There are actually two slides listing all of the records. I'm not going to go into these in a lot of detail. I will tell you that one of the other documents, which I'll show you in a moment, that we've prepared is a trust accounting overview, and it provides a bit more information about what each of the records is that you must keep and what they are. So trust journal records all the trust activity. That's chronological. You have a separate ledger for each client. Of course, you have to keep track not only of the overall amount of money in your trust account or the monies in your trust account, you have to keep track of each client's money. And that's the purpose of the separate client trust ledger. It's a trust transfer journal, which you might not use often, but there may be situations in which you are transferring money between clients. You have to keep your records of your monthly reconciliations. Um, you have also a general journal. This is mentioned here, although it is to do with your general account and not your trust account. But of course, you may be transferring money from your trust account to your general account and so on. In any event, you have to have a general journal. You have a billing journal, an accounts receivable ledger. These are all pretty uh, clear and straightforward. You have to keep supporting documents, and those are records of every transaction you make. So if it is you go to a bank and you deposit a check from a client, you get some kind of a record from the bank for that deposit, and you keep those documents and such related documents as those. Also, although we really aren't going to talk about trust, not about non-monetary trust property things that you are holding for a client, deeds, and so on. Uh, so we're not going to talk about that. It's a whole separate area, but you do have to keep a log. That's worth mentioning here, as it is one of the trust accounting records identified in the rules. Okay, so it's not going to surprise you that in addition to all of the records that you have to keep and the functions that you must perform, like reconciling your trust accounts monthly, you also have reporting obligations to the Law Society. These fall into two types. The first is a startup report that you must do within 4 months of being approved to operate a trust account. The first part of that, the firm fills out, it's pretty straightforward, and the remainder is done by somebody from an accounting firm, an accountant from an accounting firm. And really what this is it's not an audit, but it is a process by which the accountants look at your trust accounting practices over a period of time to make sure that you're doing things properly, basically. And that's, if it's a new firm and a new trust account, it's an early opportunity to help you with any challenges you may be having with your trust accounting practices. The second type of obligations are the annual ones. So you have a law firm self-report, which you must do every year before the 1st of September, and that includes an accountant's report. And that's the second report. As they sound, as the names suggest, the first report you do, and the second report the accountant does. And again, this is all of these things that the Law Society requires you to do and that involve accountants is a way of looking at what you're doing with your accounting and making sure that you are doing it properly. That is the primary goal of all of this. It's not primarily to catch bad actors who might be doing things they ought not to be doing, although it does that. But really, it's important to see this kind of obligation as an opportunity to get reassurance that you are on the right track and help if you're struggling with things. So I was in private practice for quite a long time. I've sat through many of these kinds of things. They're not a lot of fun, but they are helpful. Okay. Uh, I mentioned that the Law Society has created some additional documents. The last two here, Trust Accounting Reconciliation Overview and the template, I've already shown you. I'll show you the Trust Accounting 101 document. Covers much of the same ground as we are covering here today, and but with somewhat more detail, and in every case with specific reference to the rules where there are rules and not just general concepts. It takes you through all of that. It's just a good, if you're um, getting started, it's a good overview. It also goes through with each of the records that I've just whizzed through. It goes through what they have to include. All of this is found in the rules. The purpose of this document is just to make it a little more user-friendly. So you're not searching through the rules one by one to figure out what your obligations are, but you can see them here. The information on reconciliation is there, and even some information on the general journal that we referred to. So that's the purpose of this overview. It's to give you that general information at your fingertips, I guess is a good way to put it. The next document, which is styled as an FAQs document, is trying to deal with some basic things at the front end of it, and then trying to answer some specific questions that arise frequently. And I should tell you that these documents were all prepared, and the anti-money laundering documents, but through reference, of course, to the Law Society of Northwest Territories rules, but also looking at a lot of precedents and resource documents from other law societies. I, I, I I may be misremembering, but I think it's possible that your website, your Law Society's website already refers you to the Law Society of Alberta's website in the case of some of the anti-money laundering information. They also have very good trust accounting, but so do other law societies in the country. So although those documents won't help you with your specific rules, there is a common approach to trust accounting regulation in Canada, in every law society. And there's a lot of good information about how to deal with some situations that we just couldn't cover in these documents. In any event, this document answers some key questions. You will have more potentially, and you may find that reference to documents outside of your own law society as a way to answer those questions. So I want to, this is whizzed right by, and I apologize if I've gone too quickly, but it is an overview. So first of all, I'm happy to answer questions, but second of all, this is really just intended to introduce you to your obligations. I want to say before I invite any questions, however, that the real takeaway here is that if you are diligent and if you keep good records, you use approved trust accounting software, you seek help when you have questions and aren't sure what to do, you exercise due diligence in the management of the money that you are holding on behalf of your clients, you'll be fine. You will be fine in those circumstances. But if you don't do those things, you may very well find yourself in trouble, as I said at the start. Unfortunately, mucking up your trust accounting is one of the things that gets lawyers into trouble, and this happens in every jurisdiction in the country. So I encourage you to don't be afraid of this. Just be familiar with your obligations, fulfill them. Certain really key basics that I'm going to harp on again, that money's not available for any purpose until it is officially in the bank account, until, for example, a check has cleared. This protects you. It protects everybody involved. So that's a really critical thing, and it's easy to forget because we're in an era of instant, right? We can instantly transfer money. We can instantly do this, that, and the other thing, including with banking. But there's some things that are not instant in banking still. Checks are one of them. Checks are routinely held by the bank for a period of time before they clear. So that's something just to keep in mind and not to get lulled into a false sense of security. So that's really all I wanted to cover, but I would be happy to take any questions you might have. See something in the chat. Okay. Does the monthly reconciliation report need to be signed? Jeff and I discussed that, and I think we decided that it would be a good idea to sign them. But we do sign things electronically nowadays, and that may be sufficient. Uh, I don't believe there's any obligation in the rules that requires that it be signed. It's a good best practice, which could be printing it out and having a signed copy in your records, even though you're using accounting software to prepare it. That question came from the chat. Did anybody else have a question? No questions? One thing I'm going to mention, and this is as much for Jeff as for you, is if you're new to trust accounting and you get at it and you have more questions. So my area of expertise when I was at the Federation, my relevant area of expertise was in anti-money laundering field. And there is, as I mentioned, an intersection between trust accounting and anti-money laundering, which is how I became or renewed my familiarity with trust accounting since I had been in private practice previously. But there is a body, Jeff, I think you're a member of it, that is the Trust Assurance Group. This is a body of law society people from around the country who work in the trust safety area. And they are a wonderful resource. So I'm sure that if you have questions that Jeff can't answer, you would have an avenue through Jeff to that group to get you answers to more complex questions. Oh, I have another question. Let's see. Okay, make sure I understand this question. And we're asking about should we avoid receiving funds in a bank-to-bank transfer as there is no proper record, or sometimes clients do not send it from their end. I guess you mean by that they have somebody else send it. Well, certainly when it comes to money laundering, yes, you should, because you always want a trail. You, in fact, have to have a trail for your financial transactions to know where the money came from and to be able to track it. Now, that's possible through electronic funds transfers. So not the kind of transfer that I can just do on my banking app and send my friend who paid for something for me to reimburse him. Not that kind of a transfer, but a proper electronic funds transfer does have tracking information. But we had this question arise in the context of when we were talking about money laundering rules, because if you have to have confidence that the source of the money that you have been duly diligent to try to ensure that the source of the money that might be coming into your trust account is not dirty, you have less control over it in a situation where you have provided a client with the banking information they need on your end to be able to make that deposit, right? And given your obligations, for tracking and accounting for all of the money in your trust account, in addition to the money laundering side of things. In some ways, I think the old-fashioned way is better. Disadvantage, of course, when we're talking about very large amounts of money, as I said, which are more common in commercial transactions, for example, EFTs, as they're known, provide a lot of that tracking information. So that is potentially available to you. You have to, you know, with this, as with anti-money laundering obligations, there are sometimes not hard and fast answers to questions because it comes down to due diligence. And as you'll appreciate from any other area of your practice, due diligence requires that that you take the steps that satisfy an obligation to be diligent that are appropriate in the circumstances, right? So as circumstances change, which is why you sometimes get slightly less definitive answers to some of these questions, but that's really because you must exercise your professional judgment in these as well, and we can't give you a hard and fast answer in many cases. Any other questions? Okay, I don't see any other questions.
Great. Well, I don't see any other questions coming through either, Frederica. So thank you very much. Hopefully that was very informative for the members, and I agree with all of the suggestions you made. So if folks do have questions or would like to see more tools, please let me know, and we will do our best to get them out there and engage you if we can.
Great. Okay. Well, it's been a pleasure. And I hope you found this useful, those of you who are participating in the session today.
All right.
Thanks.